Legal Pond.
Welcome to today's episode of The Legal Pond. If this is your first time visiting this channel, kindly subscribe to the channel and share for others to also enjoy what we have here. Today's episode is going to be on a certain doctrine from common law, which is known as the doctrine of Privity of Contract. The doctrine of Privity of Contract. Let's get started.
The Legal Pond.
Welcome back. As I said early on, today we are going to focus on the doctrine of Privity of Contract. Now, one of the things that developed together with the law of contract is the doctrine of Privity of Contract. And this doctrine is very simple. It is to the effect that it is only the parties to a contract who are bound by the terms of the contract. In other words, it is only the parties to a contract who can enforce the terms of the contract or against whom the terms of that contract can be enforced. This principle was propounded in the case of Tweddle versus Atkinson, where the court gave two reasons why third parties cannot enforce a contract that they are not parties to, or why the terms of contract cannot be enforced against third parties. Now, when I say third parties, I mean people who are not parties to the contract. Now, one of the reasons given by the court in that case is that third parties are not bound by a contract because, one, they are seen as strangers to the contract, and then two, they have not given consideration to the contract. We know very well that at common law, the principle is that consideration must always move from the promisee. Therefore, if a third party gives consideration, common law does not see it as a proper consideration. And that is why third parties are seen not to be bound by the terms of contract, because they are not the ones who give consideration for the contract to work. So that is the basic principle. The principle was also reaffirmed in the case of Dunlop Pneumatic Tire versus Selfridge, where Viscount Haldane, who was the judge in that case, said that per the principles of privity, it is only the parties to a contract who can sue and be sued on the contract. Now, knowing this general principle from common law, there were some exceptions, meaning there were some conditions under which third parties could enforce a contract, or the terms of a contract could be enforced against third parties. What are those exceptions from common law and equity? What are those exceptions? The first exception under which third parties may enforce a contract which they are strangers to is under the trust system. Now, under a trust system, where the trust confer benefits on the beneficiary, the beneficiary, even though he is not an original party to the contract, that beneficiary can enforce the terms of that trust arrangement. So you can look at this case of Gregory and Parker versus Williams, where in that case, Parker owed both Gregory and Williams. So what happened was that Parker transferred his property to Williams and asked him to use the proceeds that comes from the property to pay Gregory. But then Williams failed to do that. Now, that particular arrangement between Parker and Williams was a trust arrangement that was made for the benefit of Gregory. And because of that, even though Gregory wasn't part of that trust arrangement, he could enforce that agreement against Williams. Another exception under which third parties can enforce the terms of a contract is when the term in question is a restrictive covenant. What is a restrictive covenant? A restrictive covenant is a particular term of a conveyancing contract which restricts the use of a property. So for instance, you go to lease a property. Now, you the lessee, per the terms in the lease agreement, it can be stated in there that do not use the premises for A, B, C, D. Now, that particular covenant in the lease restricts your use of the land, and that is what we call restrictive covenants. Now, the law regarding restrictive covenants is that even if you, the lessee, you want to sublease it to another person or transfer it to another person by way of assignment or any other means, that restrictive covenant binds any other party who comes to handle the property or the premises. So what it means is that if a subsequent lessee comes for the property from you, the original lessee, then that restrictive covenant will bind that particular subsequent sub-lessee, even though he is not a party to the original lease between the landlord and the original lessee. You can look at this in the case of Talk versus Moxie, where in that case, a property was sold to one Leicester. And then one of the covenants in the transaction was that the lessee should not build to cover the gardens on the premises. So there were subsequent subleases that were made. Now the last person who came for the property wanted to build over the gardens, but the court held that restrictive covenant to be binding on that third party, even though he wasn't part of the original transaction between the landlord and the original lessee. Another condition under which third parties can enforce a contract which they are not parties to is under assignment. Now, when we say assignment, it arises where a person transfers all his rights in a particular immovable property or movable property to another person. Now, when you assign all your rights in a property to a person who was not a party to that particular transaction regarding the property, that assignee will have the right to sue or be sued or enforce the terms of the contract, even though he wasn't the original party to the contract. So assignment is one of the exceptions to the privity concept at common law. Another exception is leasehold agreement. Now, if a lease agreement is made, the terms of the lease are binding on all sublessees. So you look at the case of Annan versus Emoho Trading Ghana Limited. You notice very well that the original lessee assigned his right to the lease to a third party without seeking the consent of the landlord, which was a breach of the terms of the lease. Now, the landlord wanted to enforce the terms of the lease, and the court allowed him, even though the landlord was a third party to the assignment transaction between the original lessee and the assignee. Another exception is under the tort of negligence. Now, if a party to the contract has been negligent, and then out of the negligence, a third party has suffered an injury out of that negligence, that third party to the contract may enforce it, especially under the manufacturer's liability rule. So you look at a case like Donogu versus Stevenson, where Lord Atkins said that if you are a manufacturer of goods and your goods are manufactured in a way that no variation can be made to the goods, no changes can be made to the goods until it reaches the final consumer, then you must know that you owe a duty of care to the final consumer, and that if there is any damage or injury suffered by the final consumer as a result of the consumption of the goods, then that particular final consumer may be a third party to the contract between the producer or the manufacturer and the retailer, but that third party can still enforce the contract against the manufacturer. Donogo versus Stevenson. Another thing to talk about is that even though third parties cannot enforce a contract which they are strangers to under the privity concept, the case of Bestwork versus Bestwork has held that third parties can enforce a contract in a representative capacity. So in Bestwork versus Bestwork, for instance, a man and his nephew entered into a contract where the nephew took over the core business of that man, Mr. Bestwork. And the terms of the contract was that the guy was to pay the man £6 per week till he dies. And when he dies, he will be paying the widow of that man, Mrs. Bestwork, £5 per week. Now, after the death of Mr. Bestwork, the nephew paid once and did not pay again. Now, the woman went to the court to enforce that term of the contract in her personal capacity. But the court said that she cannot do that in her personal capacity. But then if he is coming as an administratrix, then in that capacity of administratrix, he can enforce that particular term and compel the guy to be paying that particular £5 per week. Now, in all this, The Ghanaian Contract Act has also made some modifications to the rules of privity at common law. And at least you should know these provisions. If for nothing at all, Section 5, Section 6 of the Contract Act 1960, Act 25, must be known. What does this section say? Now, Section 5, subsection 1, says that, I am paraphrasing what it says, that if a contract confers benefit on a third party, then by virtue of that conferment of the benefit on that third party, the third party can enforce the terms of the contract. So the precondition here is that the contract must have conferred benefit on that third party. In other words, it means the parties must have had that third party in contemplation when they were making the contract. That is Section 5.1. So in Ghana, third parties can enforce a contract if the contract confers benefit on him. But then at common law, whether the contract confers benefit on you or not, you cannot enforce it unless you fall under any of the exceptions. So that is one difference between the common law position and the Ghanaian law position. So in Ghana, under Section 5.1, contracts which confers benefit on a third party allows that third party to enforce that contract. This presupposes that the parties must have had the third party in mind or in contemplation when they were making that contract. So it means it is not all kinds of third parties who can fall under Section 5.1. Now, there are three kinds of beneficiaries under Section 5.1, or three kinds of third parties that can fall under Section 5.1. One of them is called donee beneficiary. The other one is called creditor beneficiary. And the other one is called incidental beneficiary. Now, donee beneficiary is that type of beneficiary on whom the parties donate the benefit of the contract to. So it's not like that party has a right to anything under the contract, but then the parties themselves donate it to him. So we call him a donee beneficiary. So for instance, if I entered into a contract with Mr. A, and then the agreement is that whatever benefit we are getting under the contract goes to Mr. B, then Mr. B becomes a donee beneficiary. Then we have creditor beneficiary. Now, creditor beneficiary is that kind of beneficiary who gets benefits under the contract because he is entitled to some benefits under the contract. So, for instance, I owe Mr. A 10,000 Ghana cedis. Mr. A also owes Mr. B 10,000 Ghana cedis. Then Mr. A tells me that instead of giving the 10,000 cedis to him, I should give it to Mr. B. So in that sense, Mr. B becomes a creditor beneficiary. Then incidental beneficiaries are those who are not in the party's contemplation. So when you look at the case of Yeboah and another versus Kra, for instance, it is one case that affirms that Section 5.1 does not cover incidental beneficiaries. Where in that case, the court held that even if one of the parties have obtained judgment against the other, the incidental beneficiary cannot enforce that judgment. Now, when you look at the case of COA versus Royal Exchange Assurance, where the court said that incidental beneficiaries are not covered under Section 5.1, the only condition under which incidental beneficiaries may enforce the terms of a contract is where the incidental beneficiary is a member of a class or a group of people on whom the contract confers benefit. So it mostly happens with insurance contracts. You know, drivers insure their cars. That whenever there is an accident, any liability that arises, the insurance company will pay. But then you see, mostly they use the name of the driver to make the insurance contract. So what it means is that if at the time the accident happened, it wasn't the driver who was driving the car, then it means the insurance company would not have to pay. Section 5, subsection 2 gives exceptions to Section 5.1. Now we know from Section 5.1 that third parties on whom benefits are conferred can enforce the contract or can enforce the terms of the contract. Now Section 5.2 is saying that if the contract confers benefit on a third party and the purpose of that benefit is to maintain resale price, then that particular benefit cannot be enforced. So that is an exception to Section 5.1. The second exception is that the parties cannot enter into a contract that confers benefit which relieves a third party from liability. it is not a proper benefit under the contract, or it is not a proper benefit in light of section 5.1. So two exceptions: contract that confers benefits to maintain resale price does not fall under section 5.1. Again, contract that confers benefits to relieve a third party from liability does not also fall under section 5.1. Now, section 6 gives a supporting provision to section 5.1 to say that now, because section 5.1 is saying that if a contract confers benefit on a third party, that third party can enforce it. Section 6A is saying that if the parties have entered into a contract and have conferred benefit on a third party, then any variation of the terms of the contract which is made by the parties will not affect the benefit of the third party, will not affect the right of the third party to enforce the contract, unless that variation was made with the consent of the third party. So you look at a case like Edra Farms Limited versus Halley, where Halley acted as a guarantor to a contract between Edra Farms and Abuasa Food Supply Limited. The parties varied the terms, and out of the variation of the terms, they called upon Halley to come and then make payment, and Halley's bank made payment. And Halley sealed that the variation of the contract was not done with his consent. But the court did not allow him to enforce anything against the parties, because the court said that even though the parties have varied the terms, Halley was not a party to whom a benefit was conferred. He was only a guarantor under the contract. So they do not need his consent to vary the terms of the contract. Because section 6A says that the variation should seek the consent of the third party on whom benefit is conferred. A guarantor does not have any benefit under the contract. He even has liability under the contract. So the picture we are getting from that case is that guarantors do not fall under section 5.1. Now, section 6B also adds that in case a third party sues one of the parties to the contract under section 5.1 on grounds that he is a third party who has benefit under the contract, then that party to the contract who have been sued by the third party can raise some defenses. And the kind of defenses that he may raise include counterclaims. He may also raise the defense of set off. Now, counterclaim is an action within an action. When you look at Order 12 of CI 47, it explains what counterclaim is. So, if the third party sues a party to the contract that I have this benefit under the contract and I want to enforce it against you, the party to the contract who have been sued can also raise a counterclaim that, okay, I also have this claim against you. So he may also begin or raise a counterclaim against him and claim it. It is allowed. The same way, he may raise the defense of set-off. Set-off is when the party tells the court that it is true that I owe him this benefit, but he also owes me this amount or this benefit, so I have used his benefit to settle the one he owes me. So let's assume there was a contract between myself and Mr. A, and the contract was said that I should give Mr. B 10,000, but Mr. B owes me 12,000. So instead of me to give the 10,000 to him, I use it as a set-off. Because of that, he comes to sue me. I can tell the court that I have taken the money because I have used it as a set-off against his liability towards me. So these are some principles about the concept of privity of contract, which I believe at least you should know and understand. You can also read section 7 and section 10 in addition. But the most important provisions I think you should know is section 5 and section 6. You should know and understand them very well. If you have any question, you can ask in the comment section so that we address it. You may also channel your concerns through the numbers running on your screen for assistance. Once again, I advise you to get the Legal Companion Volume 1 and then look at the questions and answers on this topic in that material. See you in our next video.
The Legal Pond.